Good morning to those in the Asia Pacific region and good afternoon and evening to those of us joining us from the United States and North America. I am Emma Armson and I'm a member of the Herbert Smith Freehills CIBEL Centre and Associate Professor at UNSW Law and Justice. And I'm delighted to welcome you to the first session of CIBEL's 2021 Young Scholars Workshop. I begin today by acknowledging the traditional custodians of the lands on which we meet today, the Bedigal and Gadigal people, for where I am and where UNSW stands, and pay my respects to the elders past, present and emerging. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. Thank you for joining us to discuss commercial law in our changing world. Our young scholars in this session have been researching in the important areas of enforcing stakeholder interests in the context of directors' duties, transnational suppliers in global value chains, reforming personal information protection in China, and promoting a level playing field between Chinese state-owned and other enterprises. I'd like to thank my CIBEL colleague, Associate Professor Charlie Weng, for his work in bringing together the panel for this webinar. I will introduce each panellist right before they speak, and our format is that the panellists will each speak for somewhere between 10 to 12 minutes before we open up for questions at the end. Our first speaker is Mr. Param Pandya, a PhD candidate of the National University of Singapore. Param is currently pursuing his doctoral studies at NUS as the President's Graduate Fellow. He completed the Master of Science in Law and Finance at the University of Oxford as the J.N. Tata Scholar in 2019 to 2020. He is qualified to practice law in India. Prior to pursuing his Masters, he worked as a Research Fellow at the Vindi Centre for Legal Policy, New Delhi. Here, he had the opportunity to draft the Zero Draft of India's National Action Plan for Business and Human Rights. He also assisted the Government of India in drafting amendments to the Indian Insolvency Law, Company Law, among others. Before this, he worked as a corporate lawyer at CAM, a top-tier full-service law firm in India. His key interest areas are business and human rights, corporate governance and financial regulation, with a special focus on India. Param's topic today is directors' duties and stakeholder interests, the need for an enforcement mechanism.
Good morning, good afternoon and evening to everyone. My presentation aims to highlight the need for an enforcement mechanism to remedy the breach of directors' duty to consider stakeholders' interest. So my presentation is structured in a way that it first provides an overview of the director's duties to consider interest of non-shareholder constituencies such as employees, creditors, consumers, suppliers, environment and the community at large, which I refer as stakeholders. I then discuss the governance model and how these duties are currently being enforced. The second part discusses 4 principal justification for the need for an enforcement mechanism. Lastly, I welcome comments and questions. Next slide, please. So, what does considering stakeholder interest entail? For instance, if a company is proposing a new mining project, directors should not only evaluate the future profitability estimates, but also consider if the mining site, say, is a heritage site or there are environmental issues, among others. Directors' duties to consider stakeholder interests manifests into 2 major forms, the pluralist approach and the ESV or the enlightened shareholder value approach. The pluralist approach treats stakeholders' interest as an end goal and does not prioritize between shareholder interest and stakeholder interest. It's based on the stakeholder theory. So continuing the earlier example of the mining project, while a new mining site may yield higher profits, it may also provide employment and better infrastructure. So you see the conflicts. Shareholders, employees are on the one side, and the environment and the community whose heritage is being lost on the other. The issue of conflict of interest is atypical to the pluralist approach, and it increases the cost of corporate decision making. The Indian company law adopts this approach. It accords equal priority to all stakeholders, however, fails to guide on how to balance the interest of all stakeholders. Next slide, please. The ESP approach sees shareholder value or long-term interest of the company as the end goal and prioritizes shareholders' interest in case of conflicts. So again, getting back to the earlier example, despite conflicts of interest, the mining project could go through because it enhances value and leads to certain benefits to employees. This approach helps directors at times to take tough call as the priority is put together. The UK approach, the UK section 172 of the UK's Companies Act seems to adopt this approach. It says that directors must promote the success of the company for the benefit of its members as a whole, but in doing so, have regard to the interest of other stakeholders. Next slide, please. The Australia and Singapore approach towards director duties is somewhat similar, as both accord an implicit recognition to directors' duty in their respective company law. This is by virtue of judicial interpretation and also certain committee deliberations in Australia in particular. However, in Australia, the priority of shareholders' interests, shareholders' interests having a priority to stakeholder interests is a bit more clearer than in Singapore. I'm sure you by this time you have guessed the references to the example. That is where I'm referring to the Rio Tinto and the issue of the gorge caves in Australia. The case throws clear light on how board of directors actually failed to consider the issue of the heritage side, which is expressly acknowledged in the many reports that were even published by committees and also by the company itself. This site, which was very special to the local communities, there is just textually pluralistic. Since the provision has been introduced, we have not seen a case law that highlights the contours of 166(2) of the Companies Act. And India also has certain substantive and procedural barriers that do not incentivize private enforcement, such as direct action or derivative action. One may argue that public enforcement avenues are available in the form of government initiating an action in public interest. However, here again, there has been no action on this slide in this case. Next slide, please. The UK government realized that Section 172 is not having enough impact. It did undertake a consultation exercise in 2017 and adopted a disclosure-based enforcement approach. The Corporate Governance Code of 2018 and Section 414 CZA of the Companies Act requires companies to disclose how they've imbibed Section 172 in their own corporate decision-making process. But as it is inherent in a disclosure-based mechanism, there is serious lack of consequences, as the only matter that is being checked is whether it's complying or not. The quality of disclosures is left to market forces. Australia is just not novel in terms of recognition of directors' duties, but also in its enforcement. It allows both private and public enforcement to remedy breach of the director duties. The uniqueness of its model makes it as an interesting case for analysis. This public enforcement fills the void of lack of incentives for private parties to initiate action. However, it also shed light on some issues that public enforcement may face, such as regulatory capacity or political economy considerations. Next slide, please. Singapore adopts the ESV approach, but again lacks any credible enforcement mechanism. There are certain penalties for non-compliance with 157, which is the provision which provides for directors' duties, and one can initiate derivative action. But so far, there has been no instance. In fact, while there is one point that Singapore has issued a practical guidance to the corporate governance code, but this practical guidance actually is 2 steps backward. It's put stakeholders' interest as a mere public relations angle. So you see that the enforcement mechanisms are not that great with in the jurisdictions under study. Next slide, please. So this is where I'm seeking more clarity. I'll be great if the participants could provide some comments on this. I'm keen to incorporate China as a jurisdiction because it makes a good case for a developed versus developing economy. Also, there are good similarities between India and China in terms of the SOE presence among everything, but there are certain questions, such as how does an Anglo-American concept of director's duty play out in civil law China with a dual board structure? How does the provisions of the PRC company law and stock exchanges guide, which basically do acknowledge stakeholder interest and the corporation's responsibility for it, manifest in practice? I would be glad to hear from the participants on these points. So this is the gist of my presentation, which basically argues for 4 justifications. Next slide, please. So as you can see, there are 4 principal justifications: the justice justification, synergy justification, stakeholder salience justification, and accountability justification. I detail it out in the next slides. Next slide, please. The justice justification. So in all jurisdictions discussed above, which recognize directors' duties to consider stakeholder interest, but they do not provide any credible enforcement, barring, of course, Australia. This puts stakeholders in a very precarious situation as they have a right with no remedy. Stakeholders mostly lack bargaining power and enter into incomplete contracts. They may also be subject to opportunistic behavior by corporations in a case where they make firm-specific investment. Thus, to provide remedy to stakeholders against breach of directors' duties within the corporate law framework, an enforcement mechanism is required. This could also provide or link liability to other sustainability enhancing mechanisms such as human rights due diligence, sustainability reporting, and sustainable finance. Next slide, please. The synergy justification is a bit more complex. So traditionally, corporate law scholars have viewed protecting stakeholder interest as the role for external regulation. External regulations such as environmental law, labor law, financial regulation, among others. They opine that corporate law or internal regulation is ill-equipped to deal with stakeholders' concern. This view has actually resulted into corporate law being an island. So also corporate lobbying has reduced the intensity and effectiveness of external regulation to protect stakeholders. Penalties imposed by external regulation seem to have no deterrence value. So how will an enforcement mechanism complement external regulation? Breach of directors' duties will be the higher threshold, as would include breach of external regulation and even an anticipatory breach of external regulation. It could also include areas where there is lacking or absence of external regulation. However, the remedy will be corporate law based only, that is to say director disqualification or compensation from the company. It will not be an all-encompassing mechanism or an overkill, to be fair. Further, to mitigate this liability that results from the breach of directors' duties to consider stakeholder interest, compliance programs may be put in place, thereby leading to mitigating the breach of external regulation as well. If this works out well, external regulation and its enforcement will have less role, or rather in the sense would not be heavily burdened, and thus it will this enforcement mechanism would create a synergy between internal and external regulation. Next slide, please. The stakeholder salience justification basically is based on the stakeholder salience theory proposed by Mitchell, which suggests that there are 3 major factors: power, urgency, and legitimacy that provide stakeholder interest salience in front of managers. So needless to say, when then there is a remedy for breach of directors' duties to consider stakeholder interest, it will enhance stakeholder power. I'm not saying that it will directly enhance or allow stakeholders to get it at this juncture, but even if there are indirect informal remedies, it can help to enhance stakeholder power. When stakeholders' concerns will be raised through a formal mechanism, such as a direct or a derivative action, or an informal mechanism such as voice and engagement by institutional investors, it will make these concerns more urgent for managers to redress, or else consequences will follow. Further, safeguards will have to be put in place to avoid frivolous concerns. That means only the legitimate concerns or legitimate stakeholder interests which have not been considered get attention. This basically tick boxes all the three factors of power, urgency, and legitimacy, and thus I argue that an enforcement mechanism would basically lend more salience. Next slide, please. The accountability justification is quite straightforward because the problem of the stakeholder theory is that it has many masters: creditors, suppliers, consumers, employees, environment, among others. This means that the directors would justify inefficient actions or omissions in the name of stakeholders' interests. They would lobby for reforms and which provide more discretion and reduce accountability. Introducing an enforcement mechanism will bring the decisions under the scanner and serve as a discipline measure. We must bear in mind that we can't also allow stakeholders to behave opportunistically, as it is harmful for businesses. An enforcement mechanism which provides for procedural and substantive safeguards would minimize this risk as well, thereby making both stakeholders and shareholders accountable. Next slide, please. So finally, this is the scope. The first point that I want to make it clear is that I don't attempt to solve the larger debate between shareholder primacy and stakeholder theory, because evidently so there is enough research which says that stakeholders' interests are getting traction even in shareholder primacy jurisdictions. I'm not envisaging an enforcement mechanism as well, which is a pill for all ills. It's the corporate law realm needs to be left in there. At the same time, it can be made more sensitive to stakeholders' concern. So it's only for breach of directors' duties, and also is subject to three major factors, such as political economy, regulatory architecture, and the limitations of judiciary in these jurisdictions. I think while I had explained how private enforcement of direct and derivative action or public enforcement by in terms of regulatory action makes sense, I have currently not dealt with what constitutes an enforcement mechanism because that's part of my thesis, and probably you might have to wait for the Young Scholars Workshop in 2022 to get some answers. Next slide, please. That's, I think, from my end. I welcome all your questions, comments, suggestions. Thank you.
Hello, Param. Thank you very much. And if you wouldn't mind just muting. Thank you very much for your presentation. For those participating, you can start posting your questions in the Q&A section and we'll prioritise those that are the most liked. Our next speaker is Nguyen, an Assistant Professor of Law at the Temple University Beasley School of Law. May is also an affiliated scholar at the US Asia Law Institute at New York University School of Law. She researches and writes in the intersections of contract law, transnational business governance, and comparative law. Her work has appeared in the American Journal of International Law Unbound, the Stanford Law and Policy Review, the Harvard Human Rights Journal, and the New York University Law Review, among others. Prior to entering academia, Professor Nguyen practiced corporate law in the Silicon Valley office of Davis Polk and Wardwell, and served on the policy team of the California Office of the Attorney General. She earned a JD degree from the NYU School of Law, where she was a law and business scholar and an executive editor of the NYU Law Review. The topic of her presentation today is Norm Assembly in Global Value Chains.
Hello, everyone from Philadelphia. It is wonderful to be here today. Many thanks to the organizers and to Professor Armson for chairing this panel. So I am presenting today a work in progress that is still taking shape. It is an article called Norm Assembly in Global Value Chains. And norm assembly is of course inspired by the process of physical products assembly. And the metaphor is meant to invite envisioning supply chain governance as a co-production process, whereby intermediaries like suppliers and contractors, alongside their corporate buyers and other actors, all participate in the creation, interpretation, and implementation of a range of legal and business norms, spanning from contract designs to corporate liability to labor standards. Now, it is often assumed that multinational brands like Walmart and Nike and Apple, usually based in developed economies, are the rule makers in global trade, who dictate the terms of engagement to a sprawling, dispersed network of suppliers worldwide. This stylized picture of globalization is no longer accurate. Today, just as corporate retailers divest and outsource their foreign-based first-tier corporate suppliers in a parallel move have increasingly scaled up and consolidated to serve corporate demands. So as a result, a group of powerful but largely hidden global economic actors, transnational suppliers and manufacturers have emerged as a new crop of multinational enterprises. So I want to highlight just three things that animate this project. First is the rise of these so-called big suppliers, transcontinental multinational companies like Foxconn, probably the most well-known, which is the 26th largest company in the world. There are also Li and Feng, the world's largest apparel trading house, Nguyen, which makes 1 out of every 6 pairs of sneakers sold globally, Tao Apparel, that's TAL, which makes 1 out of every 8 cotton shirts that you and I wear, just to name a few. So these are the multinationals at the top of a global supply base that made possible the business empires of brands like Apple and Walmart and Target. So the second point is about supply chain governance, defined very broadly as a production network, labor and environmental standards, product safety, etc., that are increasingly being managed by these transnational suppliers rather than their corporate buyers. And finally, such economic arrangements in turn impact the ways in which certain legal and business norms and rules are so-called assembled and implemented in global value chains. And I will use some vignette examples to illustrate these points. But the overall takeaway of this project is that even though economic powers in supply chains today are still imbalanced in favor of big brands, instead of a one-way power exertion, there is a relative shifting and sharing of locus of power. And that matters, with legal implications for contracting practice, corporate social responsibility designs, just to name a few. Okay, so let me dive deeper into each point. First is about the economic story. Big suppliers are, of course, not a new phenomenon, but their legal implications and their roles in norm making are still under study. Many of these big suppliers are vertically integrated, so they are doing the reverse of the Western multinationals. There's a fascinating historical account of how that transformation happened that is highly industry specific. For textile and garment, for example, it is the quota system under the multi-fiber arrangements and its expiration in 2005 that was one key driver. So today, big suppliers manage and sometimes own to various degrees a transcontinental network of factories and manufacturers that cover the entire production process so that they can provide turnkey full service access to brands. And ironically, that include reopening shutdown plans that firms have left behind. Firms in the US and Europe and elsewhere have left behind. In the US, the latest controversy was Foxconn reopening of a plant in Wisconsin. Okay, so very quickly, supply chain governance. Let me just give one example in the interest of time. So Tao Apparel Group is a textile manufacturer that supplies for Brooks Brothers, L.L. Bean, JCPenney, among others. Tao manages its inventory through what is called an integrated synchronization service, also known in contract parlance as vendor managed inventory or VMI, whereby it takes full responsibility for maintaining JCPenney's inventory levels. Now, traditionally, manufacturing was based on a business model of so-called command demand, such that vendors simply responded to orders and had little visibility into their customers' activities. VMI, by contrast, links data from the retailer's point of sale directly to the factory floor. So when I buy a purple shirt at JCPenney, that data is collected at the point of sale through Tao's proprietary software and flows directly to the particular factory that Tao had assigned for JCPenney, which then automatically replenish JCPenney with the style, size, and color that is running low, all without the need to consult with JCPenney itself. As one Tao managing director noted, instead of asking JCPenney what it would like to buy, I simply tell them how many shirts they just bought. This is known as just-in-time 2. So that's the next evolution of Toyota's well-known just-in-time system. And the key takeaway is that supply chain governance, traditionally about managing people and products beyond the borders of brands and retailers, and traditionally conceptualized as this buyer-driven vision, are now increasingly about the internal functions of brands themselves, with suppliers taking on bigger roles. All right, finally, let's talk about norms. What norms and how does norm assembly happen? Let me give another example of Nguyen, which is one of the world's biggest manufacturers of branded footwear, supplying to Adidas, Nike, among others. Nguyen factories organize their production lines by customer. So each production line, including not only the machines, but also the workers, is responsive to the specific customer's requirements, including their codes of conduct. And that's because the footwear industry has a wide range of such codes, with Nike in particular, once the poster child of sweatshop practices. As one of Nike's major suppliers, Nguyen became embroiled in the anti-sweatshop campaign against Nike in the late 1990s, including major exposé in its factories in Vietnam. As an early adopter of corporate social responsibility, Nguyen, following Nike's lead, increasingly needs to comply with not only varying manufacturing specifications, but also a variety of codes of conduct and labor and safety standards. Because it organizes its production lines based on specific merchandisers, it was able to impose stringent standards only where required. Nguyen's business model may thus give insights into why codes of conduct and CSR efforts continue to face persistent challenges. The customer-specific arrangement arguably limits a so-called Brussels effects or California effects on overall factory conditions. So just to sum up, at the macro level, the big question that interests me in this project is the interplay between the economic forms and legal forms in global production. So in this case, how do these transnational suppliers come to be? And now that they are here, how should regulators and other actors think about them? Recognizing the relevance, organizational logics, and regulatory potentials of these actors is significant, especially in today's pandemic war, where global value chains have increasingly become arenas of not only economic activities, but also security, human rights, and geopolitics contestation. Thank you.
Thank you very much, May. Our next speaker is Ms. Luna Zhang, who's a JSD candidate at Washington University St. Louis School of Law. Luna is currently a fourth-year Doctor of Juridical Science student, a candidate, and she obtained her joint bachelor's degree in Laws and Business Administration from China University of Political Science and Law, followed by obtaining her 2 master's degrees in Laws and Legal Studies from Washington University. Her research interests lie in the fields of comparative commercial law and financial regulation, with particular interests in fintech law, privacy law, cybersecurity law, finance law, commercial law, and information law, as well as other laws in the fields of the most cutting-edge forms of financial regulation. Aspiring to be a legal expert in comparative commercial law, she would like to strengthen her intellectual background and substantive legal knowledge by conducting comparative studies on business law under an international context and in a global perspective. Luna's topic today is a comparative study on personal information protection legislative reforms in China, a progressive wave of privacy reforms in a changing world.
Hello, everyone. Thank you, Professor Armson. My name is Luna Zhang, and I'm currently a fourth-year JSD candidate at Washington University in St. Louis School of Law, the United States. First of all, I would like to express my thankfulness to the Herbert Smith Freehills CIBEL Center at Unsw Sydney for offering me this opportunity to present my work. It is such a valuable occasion for academic encounters and dialogue. Today, I'm going to conduct a presentation on my current research. The title of my presentation is A Comparative Study on Personal Information Protection Legislation in China, a progressive wave of privacy reform in a changing world. Page 2, please. Firstly, I would like to briefly walk through the roadmap of today's presentation. My presentation is divided into 6 sections. Section 1, Introduction. Section 2, the fundamental principles of credit, big data, and the advent of big data technology with its applications in various kinds of activities. Section 3, China's personal information protection legislations at a crossroads. Section 4, an important lesson to China, enlightenments from the Europe. Section 5, outlooks and proposals, finding an ideal Chinese model, and Section 6, conclusion. Next, I'm going to carefully guide you through each section in detail. In the past few years, with the gradual awakening on the protection of individual freedom, civil liberties, and human dignity, countries and regions around the world are experiencing a progressive wave of privacy reforms. Currently, China has completed 2 rounds of reviews on its draft personal information protection law and has entered the process of the 3rd round of review. A new kind of data privacy arrangement is expected to be introduced in the near future. However, at present, there is not a single unified and comprehensive personal information protection legislation in China. How to boost the legislative reforms on personal information protection in China has become an essential topic for Chinese legislators. Page 4, please. Hello? Before we can head into the concrete analysis and examinations of legal perspective of this issue, there are some fundamentals to grasp. In this section, I will briefly introduce this background information. Page 5, please. Credit is an essential aspect of human society. The concept of credit contains rich meanings. It can be examined from various perspectives of law, economy, sociology, and ethics, etc. Different angles of perspective reveal different versions of definition of the concept of credit. At the same time, the connotations of credit do not always remain the same and are gradually evolving throughout history. The progress of credit mirrors the progress of human civilization, and therefore, in a sense, the history of credit mirrors the history of human civilization. Page 6, please. After the year 2000, due to the rise of information technology, the real concept of big data has emerged. Currently, there is not an official definition of the concept of big data. The earliest definition of big data was firstly introduced by the renowned consulting firm McKinsey in year 2011. Big data was defined as data sets whose size is beyond the ability of typical database software tools to capture, store, manage, and analyze. Page 7, please. The real emergence of big data came with the birth of Internet in 1993. Nowadays, the big data revolution has completely changed our lives. The utilization of big data in various industries has become a new engine and a new driving force for economic development. While big data brings enormous transformations to human beings, it also poses great challenges to the traditional framework of personal information protection. It is increasingly important to strengthen the governance of big data technology with its applications in various forms of activities. Page 8, please. After understanding the basic issues, it is time to examine the flaws and limits of existing standards and norms on personal information protection in China. In this section, I will firstly illustrate the 4 categories of personal information protection standards in China. Secondly, note several major laws and regulations governing personal information protection in China. And thirdly, articulate the flaws and limits of existing standards in China. Page 9, please. My research divided the current existing China's personal information protection laws and regulations into 4 categories, according to the levels of their ranks in jurisprudence. The first layer is the constitutional law of People's Republic of China, because the Constitution has the highest status in the legal hierarchy and is the most essential fundamental law among all law departments. The second layer is ordinary law, such as the Civil Code of People's Republic of China and the Criminal Law of People's Republic of China. The third layer is administrative regulations, such as the Telecommunication Regulation of People's Republic of China. The fourth layer is the departmental regulations, such as the Regulation on Management of Internet Electronic Node Services. Currently, there is not a single, unified, and comprehensive personal information protection legislation in China. Page 10, please. Major laws and regulations governing personal information protection include, just to name a few, the Constitutional Law, the Civil Code, the Amendment 7 and 9 of the Criminal Law, the Cybersecurity Law, the Tort Liability Law, and the Consumer Rights and Interest Law. Page 11, please. Generally speaking, the current legislation on personal information protection in China is mostly indirect, fragmented, and is in overly general provisions. At present, China's legislative branch has already finished the review of the first and second drafts of its personal information protection law. A sound, strong, and comprehensive personal information protection mechanism in the era of big data can be expected in the near future. Right now, there are currently 3 major insufficiencies existing in the personal information protection laws and regulations governing big data credit reporting activities in China. These insufficiencies are, firstly, lack of a single, unified, and comprehensive personal information protection mechanism. Secondly, lack of a clear definition of personal information in current legislation. And thirdly, lack of a comprehensive and effective legal enforcement mechanism. It is imminent for China to establish a well-rounded personal information protection in credit reporting activities in an era of big data. Page 12, please. In section 4, I'm going to analyze the current personal information protection legislative metrics from European perspective in order to provide proposals for the personal information protection in China. Page 13, please. Europe is the birthplace of modern data protection laws and regulations. The European Union has the highest standard for personal data protection, with the most comprehensive and stringent data protection legislation in the world. Stemming from the Personal Data Protection Directives, the EU General Data Protection Regulations, known as GDPR, was approved in 2016 and effective in 2018. It is regarded as a symbol of the new era of big data governance. GDPR. Okay, all right, thank you. GDPR can not only protect the individual's rights of EU citizens from the infringement of personal information, but also is a key step of EU's global strategy. In the era of information society, GDPR makes EU the leader of the global digital economic order. Page 14, please. In section 5, I'm going to illustrate the enlightenments from the current legislative model in European Union and provide suggestions to find an ideal Chinese model on personal information protection. Page 15, please. The European Union legislative model on personal information protection has three essential aspects. Firstly, a single, unified, and comprehensive law on big data credit reporting. Secondly, a definition of personal information in a single, unified, and comprehensive law. And thirdly, a sound legal enforcement mechanism on big data credit reporting. My research believes that China should facilitate the current legislative mechanism on the protection of personal information in big data credit reporting activities in at least three corresponding aspects. Page 16, please. The case of China is like a chaos today and a promising prospect tomorrow. Having finished 2 rounds of reviews, China's GDPR is just around the corner. Besides China, the European Union and the United States legislative model on personal information protection originate from their unique economic, social, political, culture, and historical backgrounds. China should also explore the effective ways and means to protect its citizens' human interests, rights, dignity, and freedom based on its own conditions. Page 17, please. To sum up, my research in the intersections of privacy law and fintech law aims to answer the following questions. Could you please give me 3 more minutes to wrap up my presentation? Phil? To sum up, my research in the intersection of privacy law and fintech law aims to answer the following questions. What is the future of credit reporting industry in China? How should China develop its credit reporting industry within a superior legal framework? How will traditional credit reporting activities develop with the advent of modern big data technology? What are the legal problems of and their countermeasures to the currently existing legislations on personal information protection in big data credit reporting activities in China? What are the enlightenments from data protection legislative metrics in Europe? What are the Europe can borrow from the current legislation of personal information protection in China? Page 18, please. These questions expect answers, yet without question. The advent of the era of big data, with its applications in financial activities, will continue changing the traditional financial ecosystem and transforming the world. Page 19, please. The world is constantly changing with a progressive way of social revolutions in forms of judicial reforms. Fixating on the judicial reforms in forms of privacy renovations will lead us to a stage of superior information privacy governance. My research, embodied in today's presentation, expects to fasten one facet of the privacy renovations in forms of personal information protection legislation. Privacy is a human right. As the Article 12 of the Universal Declaration of Human Rights states, no one's privacy, family, residence, or communication is subject to arbitrary interference, and his dignity and reputation are not subject to unjustified attack. The protection of personal information is not only the demand to protect personal interest in the public and private sphere, but also directly relates to national information surveillance, cultural sovereignty, and economic development. In order to build a stronger and healthier credit reporting industry in an era of big data, it is increasingly essential for China to establish a sound personal information protection legislative mechanism to protect its citizens' human dignity, civil liberties, and individual freedom based on its own condition. That's all for today's presentation. Thank you for listening.
Thank you very much, Luna. Our final speaker is Dr. Sophia Bai, a PhD graduate from UNSW Law and Justice. Sophia has been awarded a Doctor of Philosophy degree at UNSW Law in 2021, where she conducted doctrinal research on the reform of Chinese state-owned enterprises, what China can learn from the practice of competitive neutrality policy in Australia. Prior to commencing her PhD degree, Dr. Bai was awarded her LLB and LLM degrees in law at Beijing Jiaotong University. Dr. Bai's current research is in the area of competition law and policy. Her recent co-authored article is published in the International and Comparative Law Quarterly on China's SOE reform using WTO rules to build a market economy. Sophia's topic today is reform of Chinese state-owned enterprises, what China can learn from the practice of competitive neutrality policy in Australia.
Hello, everyone. I would like to thank CIBEL for inviting me to speak at this workshop. What I will talk about today is largely three-part. What is competitive neutrality and what is not? Why competitive neutrality is important and how to achieve competitive neutrality, especially for China. Next, please. The term competitive neutrality is a multi-dimensional and somewhat abstract concept. There are different ways to understand the term depending on the context. For example, in transnational discussion like international trade regime, competitive neutrality often refers to no entity operating in a market is subject to undue competitive advantages or disadvantages. Under this definition, the primary cause of competitive neutrality concern is less relevant to ownership and has more to do with home country measures like state aids or the use of industrial policy. By contrast, competitive neutrality, when discussed in domestic perspective, focus mostly on the participation of SOEs in the market. For example, competitive neutrality in Australia refers to government's business should not enjoy any net competitive advantage simply as a result of their government ownership. For the purpose of today's presentation, competitive neutrality is discussed in Chinese market and refers to a guiding principle that SOEs, when competing with other firms, should not enjoy competitive advantage merely because they're government ownership. It is worth clarifying here that competitive neutrality does not become relevant to the question of whether to reduce the existence of SOEs in the competitive market, or even a bigger question of whether SOEs should exist in the first place or not. Competitive neutrality in this sense is secondary to the matter of privatizing SOEs or retaining government ownership in a firm. What is more relevant to competitive neutrality is when SOEs are engaging commercial competition, how a neutral market can be maintained without changing the innate nature of the firm. Next slide, please. Government ownership within SOEs can generate competitive advantages, such as have better access to bank loans, borrow money at lower cost. For example, lending to state-owned enterprise often perceived to have a lower risk, and this is often reflected in lower interest rate. And have better access to public resources like land free of charge or at a lower commercial rate. SOEs, when competing, can benefit from this kind of competitive advantages and take business away from more efficient firms in competitive market. In addition, the dual role played by government in the market may cause competitive neutrality concern that governments have incentive to favor SOEs over other competitors. In particular, government as a shareholder has incentive to maximizing its financial interest in its commercial firms. However, government as a regulator oversees commercial activities of all market players. This outcome is undesirable from a competition point of view for several reasons. Firstly, allowing SOEs to compete based on their government ownership generated advantage sends the wrong signals to market participants, which is that to succeed against the rivals, firms need to pursue government ownership rather than focusing on performing activities more efficiently than their competitors. Secondly, allowing SOEs to benefit from their government ownership is likely to lead to sub-optional use of resources, because a market that allows less efficient firms to survive is unlikely to ensure their goods and services are delivered at the lowest possible cost. The comparative study in Australia found that SOEs in the market does not necessarily cause concern if anti-competitive conduct of SOEs is successfully regulated by the competition law, and there is a competitive neutrality mechanism in place to maintain a level playing field in the market. Based on this observation, I evaluated the ability of current Chinese competition law or the anti-monopoly law and competition policy to maintain a level playing field in China. The finding in my research suggested that current Chinese competition law and policy may have limited effect in ensuring a level playing field between SOEs and other market players. In particular, I found that while there are cases suggested SOEs, like all the other market players, are under the coverage of competition law and will continue to be so in the future, enforcing competition law against the SOEs poses additional difficulties to Chinese competition authority. For example, merger enforcement can be effected by the involvement of Chinese SOEs. The concentrating of central SOEs, or Yangji, is often published by SASIC, the supervisor of central SOEs, before it has been cleared by the competition authority. In addition, I found that while fair competition review system is designed to address unjustified competition restraint imposed by regulatory policy, the application of such policy can address only part of the competitive neutrality concern, the regulatory advantage enjoyed by Chinese SOEs. This means that more needs to be done to address the lack of level playing field between SOEs and other competitors in China. You probably wonder why China needs competitive neutrality. For people who is now familiar with China, it is essential to know that different stages of SOEs reform have altered the relationship between government and Chinese SOEs. However, the connection between SOEs and government and political authorities still exist. The current reform SOEs introduced in 2012 also increased the pressure on Chinese SOEs to be more competitive in both domestic and international market. My paper argues that adopting tools to encourage SOEs compete based on efficiency rather than on government ownership generated advantage will greatly benefit China, a country with a substantial number of SOEs active in the market. Having effectively enforced competition law and a Chinese competitive neutrality in place will bring increased domestic competition. This strong domestic competition environment would push companies, especially SOEs, to improve their efficiencies through means like innovation in order to survive in the competitive process and eventually toughen them up for the international competition. The protection of SOEs from competition at home, on the other hand, may make them less likely to succeed in the international market. To ensure a level playing field between SOEs and other competitors in mainland China, I proposed several measures for government to consider. First, the measure is to reform Chinese anti-monopoly law to address SOEs more effectively. I suggested Article 7 could be deleted, and the possible exemptions available to SOEs should be evaluated in a systematic manner. In addition, I suggested that China should consider introducing competitive neutrality policy in a gradual manner, while main content of competitive neutrality will be decided by Chinese policymaker based on the identified competitive neutrality concern unique to Chinese SOEs. I explored several ways for regulators to consider when drafting such policy in my paper. For example, I proposed regulatory neutrality that requires policymakers to ensure, as far as practicable, that SOEs operating in the same regulatory environment as non-SOEs competitors. Policymakers choose to provide a different regulatory treatment for SOEs should demonstrate in writing why this different treatment is necessary for the purpose of competitive neutrality policy. Thank you.
Thank you very much to all of our speakers. We are now going to have a Q&A session. And hopefully you've already opened up the live event Q&A, the question mark column on your screen. And what we'll be doing is looking at the questions that have been posted and the most liked. I might start off with the question from, apologies if I mispronounce your name here, Mr. Habib Alam. And he asks, how should we draft the commercial contracts to compromise the impact of the COVID-19 situation? And I'm assuming that this is being directed to May.
Sorry. Oh, here we go. Okay, can you hear me? Sorry, I'm having some trouble unmuting myself. Thank you very much for your questions. So the question is, how do we draft commercial contract going forward now, knowing the risk of the COVID-19 pandemic? And of course, this is the million-dollar questions that all the lawyers around the world are working on. So from the U.S. sort of contract law perspective, I think the answer to this will depend on whether you are a formalist or what we call a relationalist. So as a formalist contract person, I would say we would have to make sure to show up those force majeure clause in this commercial contract. We have to make sure we understand how these clauses will be enforced in different jurisdictions to take into account this new risk of the pandemic. Relationalist contract lawyers, of course, will counter that it's not the formal contract that matters in business relationship, but really it is the informal norms, industry norms, that makes a difference. For my own research, when COVID-19 hit global value chains, and I did some of my fieldwork in Vietnam, the suppliers that I talked to say no one bothered pull out the formal contract to see whether there's a force majeure clause. People just scramble to figure out how to reshuffle their supplies, how to cover the contracts, and work together to figure out some kind of compromise. So relationalists would say it's about the industrial norm, the business norms that matter. And of course, there's the braiding theory of contract, where it's the formal and the informal together, where we have a formal contract, but also try to figure out where the informal mechanisms are most salient. Thank you very much for your question.
Thanks very much, May. The next question is for Param. Can you talk more about the reasons for the lack of enforcement by the government and privately in India in relation to directors' duties?
Thanks, Emma. So the question is quite pertinent because private enforcement in terms of direct action, stakeholders have no remedy whatsoever. Direct action can be taken up by shareholders and they can advocate for the causes of stakeholders. However, the remedies provided in the company law itself don't allow stakeholders' concerns to be assuaged by shareholders. So on the direct action front, this is the problem. On the derivative actions front, the class action provided under Companies Act has many procedural barriers because of which stakeholders cannot approach directly to launch a class action. And also, few of the class actions that have been put together have not been successful in terms of the shareholders raising concerns against the company. It's not clear also whether common law derivative action, which is non-statutory derivative action, is clearly recognized. But there again, we have not seen derivative actions in India generally. Some institutions, institutional investors have reached out to companies and have engaged with them to make to take environmental issues and others into light. But that also has been just engagement and no definite action. On the government enforcement, there are two possibilities of enforcement, but these are a bit, they are always shareholder centric. They're not meant for stakeholders. Again, the lack of political will and industry political nexus would be another reason why the government is not too keen to take up action. And the SEBI, who's the securities market regulator, it might just be ending up into a tricky, tough battle between the Ministry of Corporate Affairs, which is the relevant regulator under the Companies Act, vis-a-vis the listed companies which SEBI regulates, and they don't have a direct power to enforce the director's duties section 166. So this is the complex merit and why there is actually no enforcement of the same in India. Thank you.
Thank you very much, Param. If I could pick up the next question for Luna. It says you mentioned in your presentation that both the European Union and the United States have mechanisms in statutory law and case law governing the effective protection of personal data. Since China is a civil law country with statutory jurisdiction, how would you address the issues of statutory law versus case law when you attempt to incorporate the advantages of the standards and norms in both regimes?
Okay, thank you very much for your question. In my opinion, there is no definite boundary between statutory law countries and case law countries. For example, although China is a civil law country, it is learning from the legal behaviors from the country with case law. The Supreme People's Court of People's Republic of China issue China guiding cases frequently. This is called the China Guiding Cases Project. Basically, these guiding cases disseminate for Chinese judge, prosecutors, lawyers, and other legal professionals to learn from. In contrast, in a case law country such as the United States, there are still statutory laws. Take the United States as an example. The Uniform Commercial Code in the US is an example of statutory law in a typical case law country. In my opinion, there is no contradiction between statutory law and case law. They can coexist in a legal jurisdiction without confronting with each other. So this is my answer to the question. Thank you very much.
Thanks, Luna. If I can direct the next question to Sophia, what impact would adopting competitive neutrality have in relation to the protection of Chinese small and medium-sized enterprises? Do you think protection of SMEs should be one of the objectives of Chinese competitive neutrality policy?
Thank you, Emma, for the question. It is indeed a very good question. Personally, I think the purpose of adopting competitive neutrality policy in China is to protect competition or competitive process by requiring that competition between SOEs and other competitors is based on efficiency rather than who can benefit from government ownership or political connections. It seems that adoption of such policy can benefit the development of Chinese small medium enterprise to some degree. What I can think of is the adoption of debt neutrality could potentially improve the allocation of bank loan situation in China. In this sense, small business enterprise will benefit from adoption of such policy and will have better access to bank loans in practice. However, in my opinion, such an outcome is achieved through the increased competition from the adoption of this policy. And the purpose of introducing competitive neutrality policy should not be interpreted as to protect certain competitors like small and medium enterprises. Thank you. I hope this answers the question.
Thank you very much, Sophia. I'd like to come now back to a question that was asked of May. You've spoken about the challenges of implementing codes of conduct for suppliers on assembly lines. Can you talk about the impact of regulation at point of sale in relation to those assembly lines?
Thank you very much for the questions. So by point of sale, I assume you mean the corporate store, the retailers, right? So a shirt is shipped from Taiwan or Vietnam to a JCPenney store, for example, in Philadelphia, where I am, and that's the point of sale. So because these stores are in different jurisdictions, so the regulations, a great question is a very complicated one because it's affected by the jurisdiction of where the store is. So in the United States, with regards to codes of conduct, the United States has adopted generally a sort of sunshine in the best disinfectant kind of approach, to quote Justice Brandeis. So it has, just like the securities regulation regime, it has generally adopted a disclosure model when it comes to codes of conduct and CSR. So at the state level, it is California with its supply chain, modern supply chain risk law that is sort of the most advanced in this area. At the federal level, there's currently no specific body of law, but there's various provision within various federal law that regulate suppliers' code of conduct. The Dodd-Frank Act, Section 502, for example, is one that's specifically to critical minerals. And then countries in Europe like the UK and France are much more advanced in this field. The UK Modern Slavery Act, France Duty of Vigilance law impose much higher standards on companies at point of sale. Thank you.
Thank you very much, May. Now, there's a question here, a follow-up question for Sophia. Who should be responsible for implementing competitive neutrality in China?
Oh, this is another good question. I talked about this in my papers. I think the principle of government who owns or controls SOEs shall be responsible for the implementing of such policy. This means the owner of SOEs need to assist SOEs to implementing competitive neutrality arrangement. However, one potential issue with this self-implementing approach is the lack of supervision and potentially transparency. In my opinion, the design of complaint handling process could potentially remedy this shortcoming. Therefore, for design of complaint handling authority, I think competitive neutrality the responsibility should not fit in with one government authority. So I suggested to consider have multiple government regulators to handle such complaint. I think SASIC, the supervisor of SOEs, can have a formal role in handling such complaints, and competition authority in China, SAMR, could act as an advisory to SASIC. Thank you.
Thank you very much, Sophia. Now we have another question here for Luna. In your presentation, you mainly conducted comparative study on personal information protection based on the examinations of the current existing EU law and Chinese law. I'm wondering how the other countries and regimes around the world are responding to the same issue. Are there any lessons that can be learnt from the other countries in relation to the questions you are examining in your research?
Thank you very much for this question. Lots of countries around the world are responding to personal information protection legislation, such as the United States, India, Brazil, the United Kingdom, and Japan, etc. It has been a global tendency to enact norms and standards on personal information protection. There is a lot of enlightenment for Chinese legislators to learn from. Take the legislative approach in the United States as an example. The United States takes a decentralized, market-oriented legislative model. Besides the single, unified, and comprehensive model in EU, as I described in my presentation, the US legislative model is another major model. It is valuable for China to learn from the advantages of both the EU model and the US model. Thank you. Hi, I have
Thank
finished.
you very much. Sorry
Thank
about that. Very sorry. Now I'm having a technical issue. I'll be back soon. Great. Okay. Okay. Now, okay, so I have another question for Param. Why do you think an enforcement mechanism for directors' duties to consider stakeholders' interests is required?
So yeah, that's a interesting question. Of course, the most important one is that there is a right and there's no remedy, which makes no sense in the first place. Second point is that increasing stakeholders' interest stakeholders will occupy the central role as we go by. COVID has accelerated that, which means that we will have directors who are not accountable to anyone, and stakeholders may want to get their concerns heard by whatever way possible. In this case, an enforcement mechanism would provide a structural answer to both these issues, that it will ensure that directors are accountable. At the same time, stakeholders get an avenue, and that also is not, they also don't act rogue. So even with three principal justifications of the fact that A, a remedy for a right is must, B, directors need to be accountable even in a stakeholder-centric world. They cannot just argue for stakeholder interest and hide their inefficiencies. At the same time, stakeholders should also not be allowed to stall businesses at any cost. So their providing legitimacy to them is also important. So I see that these are the reasons why we need an enforcement. The contours of it can be, of course, worked out.
Thank you very much, Param. Now, I have a question that has come from May, and this is directed to Sophia. China's recent development work guide mandates the Chinese SOEs follow the higher global standards re-environmental protection rather than more lax local laws if there's a conflict. How will this impact Chinese SOEs' competitiveness globally, if at all?
Thank you. This is indeed a really great question, because we talk about SOEs have competitive advantage because of their government ownership. So it's in the same time, they also suffer from competitive disadvantage because of this government ownership. One example is a higher standard of environmental responsibility. Another is social responsibility. Sometimes, like during COVID, SOEs have higher responsibility with supplying goods and service to affected zones. So this definitely will affect SOEs competitive globally, that's for sure. However, competitive neutrality requires SOEs. Competitive neutrality does not forbid SOEs to performing social services. It just require SOEs to do it more transparent, and if you want to achieve public objectivities, you need to weight it up and be transparent. Thank you. Hope this helps.
Thank you very much, Sophia. Now, apologies, we are having some issues with the Q&A, so our apologies if you posted a question and it hasn't quite come up yet. I'll wait to see if there's any more coming through, but in the meantime, I have another question for Luna. And Luna, you were focusing very much on the EU rules, the data protection rules, because they are a single set of data protection rules. But I understand that there is a more fragmented system that's adopted in the US. So the question for China appears to be choosing between these two models.
Yes.
And in what approach, in your opinion, should China take?
Okay, this is a great question. So basically, there are two major legislative models existing in today's world. The first one is the US legislative model, and it is a decentralized market-oriented legislative model, and another one is the EU model. So it is a single, unified, and comprehensive set of rules. So China is legislating its personal information protection law right now, and the draft has already entered the third round of review. So my research proposed that China should learn from the enlightenments from both the EU model and the US model. So basically, I would like to take the single, unified, and comprehensive set of rules as one of the advantages that China should learn from. So the advantage from the US model that China should learn from, in my opinion, is that the self-regulatory legislation in the current conduct in the US. So in my opinion, I basically propose that China should learn from the enlightenments from both legislative models. Thank you.
Thank you very much. Now, it appears that we don't have any further questions from the audience, so I might wrap up our discussion now. And I wanted to thank our excellent speakers for their presentations. And it's interesting because when we started, they seemed to be disparate topics, but as I've listened to our speakers, we started off with Param talking about corporate social responsibility and the enforcement of stakeholder interests, and that was an element of May's discussion when she was talking about global protection, and May also talked about the use of personal information, which leads us into Luna's presentation. And Sophia, your discussion of the state-owned enterprises and competitive neutrality is obviously a very burning issue, which is very important. So I would like to, on behalf of the Herbert Smith Freehill CIBEL Centre at UNSW Law and Justice, I would like to thank the speakers for their presentations and for the webinar participants for your engagement with their research. I also want to thank our CIBEL administrators who've worked behind the scenes to make this webinar run smoothly. We also have 3 other Young Scholars sessions today, and the details for that were posted at the start of our Q&A session today. I'm just wondering if it might be possible just to repost that at the end. So we have another one that's starting in half an hour if you're interested in joining us for that. There are also CIBEL Global Network virtual conference panels every 2 weeks until October. And you can register for any of these events on the CIBEL website. We hope that you stay well and wish you all the best in these difficult times. Thank you very much for joining us today.